The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
You may be seated. This afternoon we have 3 cases for submission. The first case is in the matter of the estate of Sandra R. Franken. The second case is State of Iowa versus Boyer. The third case is, excuse me, Iowa Supreme Court Attorney Disciplinary Board versus Dwayne Gotkin. The third case is non-oral and will be considered submitted as of now. We're ready for the argument in estate of Sandra R. Franken, and is it Mr. Thorson?
Yes, Your Honor. May it please the court. My name is Larry Thorson, and I'm here to represent Desi and John Rottinghouse. The Rottinghouses live near Waterloo. They have a farm there. They've owned that farm for many years. It's been with their family for many years. In 1973, they decided to sell a portion of the farm, 4 acres, to John Rottinghouse's sister. Her name was Sandra Kipp at the time. It's now Sandra Franken. They decided they would convey that portion of the property by deed, and in that deed they had a restriction, or I should say a right of first refusal, to purchase the property back from the grantors of the deed, the grantees of the deed, for a price equal to the any bona fide offer to purchase that property by any third party. 15 days notice was provided in the deed. Again, they wanted to do this with restriction because they wanted this property back if it ever was sold by John's sister. The deed itself was recorded, and eventually Sandra Franken passed away. Her estate was opened, and the right of first refusal was ignored by the estate. The deed was prepared by the Beecher firm, by Louis Beecher. The estate was opened by the Beecher firm, and John and Desi were both represented by the Beecher firm. The way the Rottinghouses learned that the property had been sold was Mrs. Rottinghouse saw the neighbors taking down a fence, or the people the people that bought the Franken property taking down a fence, and that's when she learned that property had been sold. The matter was a claim was filed, proof of claim was filed in the estate by another Waterloo firm. The matter was set for a hearing. Before the hearing, there was a summary judgment motion, and the court ruled on that motion, indicating that Iowa Code Section 614.17a prevailed, and since the Rottinghouses had never re-recorded anything in compliance with that code provision, they didn't have a right of first refusal. The language of that section...
I have a question about that. There were some transfers between, first of all, the first husband died, I remember, and she remarried, and then made a transfer to her second husband. Is that correct?
She did. She transferred it into both their names, yes, Your Honor.
Well, wouldn't that trigger the right of first refusal? And wouldn't any statute start running from that first deed, rather than the deed 3 or 4 down the road?
It wasn't a bona fide purchase. It was simply a transfer for convenience of their marriage. I don't think it would have triggered that right of first refusal, since the language of the right of first refusal talked about a bona fide purchaser. And eventually that property was transferred back into her name alone. So I don't think that triggered the right of first refusal or extinguished it, if that's what the court is asking, Your Honor. The language of 614.17a is, I think, ambiguous. It talks about a claim. In this instance, we're not making a claim. We had a contractual right, I believe, but we didn't have a claim like a lien or a mortgage or anything of that nature in this instance. Originally, the
If
estate...
that section doesn't apply, what section of the code would apply to create a statute of limitations for that transaction other than the stale use and reversion statute? Is there another statute that would have a statute of limitations on that claim?
I don't believe so, Your Honor. I think that originally the estate thought that 614.24 applied, and that talks about a reverter or reversion, that type of thing. But this is not a reversion. This is a new purchase of the property based upon another bona fide offer. So I don't think that provision applies. I think if you read Marshall, which is kind of the Bible for real estate attorneys, it also talks about what a reversion is and what a reverter is, and a right of first refusal is neither of those. And it's not a restriction on use either. It doesn't fall into that category because there's no restriction on the use of the property. It's just triggered again if there's a bona fide offer and the party wants to match that offer and buy the property.
Didn't we, in a state of Horde, I think it was an opinion written by Justice Apple, talk about 614.17a and say it's a marketable title statute, and really what it does is place a burden every 10 years to file a statement, in effect kind of renewing the instrument? And how do we explain that decision?
Well, I think the decision is a reasonable decision based upon what it applies to. But again, that would be for a claim or something underneath the terms of that statute. And I don't think a right of first refusal falls under that statute. I think we're here basically because a law firm made a mistake. And I think that they made a mistake when they read the title to the property and didn't notice the fact that the deed that they prepared had a right of first refusal in it. Now, it was many years ago, but again, I think that provision or that contractual right still exists. And I don't think this does anything to slow down the marketability of title to a property. I think you can still market the property to anybody else you want to. You just have to tell us, the rotting houses, that you're doing it.
I've never been a real estate lawyer. Is there any possibility that in the course of doing the necessary title work to transfer the property, in this case, that a competent lawyer would not have come upon the right of first refusal? I understand your point that it's the same lawyers involved, but suppose it hadn't been.
Well, I think they're competent attorneys, Your Honor. I just think that they didn't look back far enough in the abstract to see that provision there. And I think that it would be part of the 40-year Marketable Title Act. I think it would be in there because this is the root of title to this property.
Would a reasonable interpretation of the statute mean the claim arises only when the right of first refusal is triggered, that is, by a bona fide offer of purchase?
I believe that would be one reading of it, yes, Your Honor.
And a statute of limitations would be the 10 years for breach of a written contract. I'm not sure if there would be others that might apply specifically to a right of first refusal.
I believe that's right, Your Honor. I think that would be the limitation that we're talking about here.
Under that interpretation, you win, right?
Yeah.
Okay.
I don't know that the procedural history in this case matters much. I think there's been a lot of different things thrown up against the wall here, but I think the court, in guidance to Iowa attorneys, should take a look at these statutes and tell the Iowa attorneys whether or not a right of first refusal is something that is covered by either statute. Because there are a lot of different instances. There are probably thousands of instances out there where rights of first refusal exist, and attorneys may not know whether or not they're still in effect or not.
View would be this is covered by 614.31, but not 17A.
My view is 17A does not cover it, yes, Your Honor. And I believe that the opinion of Justice Tabor, Judge Tabor, I should say, Chief Judge Tabor, kind of goes down step by step the reasoning that I think we also had in this case as to the contractual right we're talking about, the fact that the statute does not apply in this instance, 614.17a or 614.24, which are the two statutory provisions that the defendant in this action seem to rely on. And I think that basically what we're dealing with here is a situation, like I said again, where a mistake was made. Our only remedy at that point in time was to bring a claim to the estate and for our contractual rights. With regard to the situation with regard to the, with regard to the decisions that have been made by the Court of Appeals, I think to the extent that they say that a right of first refusal is governed by those statutes, they're incorrect. I think that the statutes themselves have language. Unfortunately, they don't have definitions of all the terms that are used in the statute. But I think if you go back and research it as far as the language of this court and the language of marshals, for instance, that there would be an exclusion for a right of first refusal from either code section. In this case, we're asking for relief from the court that this matter be sent back down for trial in the probate court based upon the fact that we believe that the incorrect statutes were used to terminate our proceeding in that court. Thank you, Your Honor.
Thank you very much. Mr. Brakhahn?
May it please the court, my name is Chad Brakhahn, and I represent the estate of Sandra Franken in this matter. The estate asks this court to affirm the decision of the Court of Appeals, which affirmed the decision of the district court, granting summary judgment in favor of the estate. The Court of Appeals properly rejected the three limited arguments that were made by the appellants in this matter. Specifically, one, that the appellee failed to timely assert Section 614.17a as a defense. Second, that the estate was the proper party to assert Section 614.17a as a defense. And then third, that a right of first refusal is not a, quote, interest in or claim to, close quote, or not close quote, real estate, close quote. On request for further review, the appellant has shifted their position. And their argument now is that Section 614.17a leaves open a possibility of a breach of contract action where a claim otherwise may still be barred in some form or fashion by Section 614.17a. This ground was not argued on appeal to the Court of Appeals, and it's fundamentally different than the issues that were decided by the Court of Appeals in this matter. The estate's position is that as an initial matter, this ground, this idea of a contract claim surviving should not be considered by this court. But if it is in fact considered by this court, summary judgment is still proper in favor of the estate because the text of 614.17a supports the district court's grant of summary judgment. And furthermore, there are numerous alternative grounds in the record which were advocated by the estate to support their motion for summary judgment, specifically that there was a merger of any alleged contract into the deed, that the statute of frauds would preclude any contractual claim based on a right of first refusal from 1973 that was not signed by the decedent, and then third, that a statute of limitations, if in fact there were a contract claim, the 614.1 sub 5 10-year contract statute of limitations would bar the claim.
Let's talk about the contract claim for a minute. If we're just talking a breach of contract claim, a personal claim against the estate as opposed to a claim enforced against the property, wouldn't it be true that the 10-year statute for breach of a written contract doesn't start to run until the contract's actually breached?
I think that's accurate, Your Honor, and the breach, the right of first refusal in this case, if there was a breach of it at all, would have been triggered by the 2005 transfer from Sandra to herself and her then husband. That was a conveyance, and we would argue, Your Honor, that a conveyance is within the scope of the alleged right of first refusal in the 1973 deed. That conveyance happened on October 21st of 2005. It was recorded 5 days later on October 26th, which would provide any notice of an alleged breach.
All right, and then the second, on the merger issue, what I understood, the way, again, you're dealing with an area where I'm out of my depth, and I apologize for that. But I thought the notion of merger was that you can't assert a contract that isn't set forth in the recorded instrument in the deed, whereas here, the contract, the right of first refusal, is part of the deed, isn't it? I mean, it's in there. It's just, so that strikes me as something different from what we're normally talking about as merger. Am I incorrect there?
I think you're right, Your Honor, that the idea behind the merger doctrine is that we're not going to look at extrinsic evidence or other contractual terms which may have existed prior to execution of the deed. Now, I think this applies in this situation. It can go one of two ways. We say the only contract in this case, therefore, if there even is a contract, and we would argue there's not, is the deed, not a contract. And so you don't have a contract claim if you don't have a contract. But let's say that is a contract. You would have, at a minimum, a 10-year statute of limitations on it. However, it's not a contract that's signed by the decedent. It was signed by the decedent's husband at the time in 1973. So to the extent there is even a contract, we have a statute of frauds issue then, which goes to the second alternative ground for summary judgment that was advocated by the estate, which is there's actually no signed written agreement signed by the party charged, which is the decedent here by way of the estate, which would allow that to be enforced as a contract. I think that they're somewhat related in the way they apply in this case.
Going to your first argument that the breach would have run from the first deed, the way I read the right of first refusal, it requires to purchase the price equal to a bona fide offer to purchase the premises. And that first transfer between husband and wife was not a bona fide offer to purchase. It was just correcting title and putting in her husband. And the only time there was a bona fide purchase or a bona fide offer to purchase by a third party would have been within the 10-year period.
I would look, Your Honor, at the first line of the right of first refusal language, which provides that they agree not to sell or, quote, otherwise convey the property. The otherwise convey would be rendered entirely superfluous if all we were talking about is sale for the exchange of money.
Well, if you take yours literally, it says at a price equal to a bona fide offer to purchase. At that time, since there was no consideration, they could have picked it up for nothing. I mean, that doesn't make any sense either.
I think the idea, if that were to happen, one would argue, I think that you're absolutely right, that perhaps at that period of time, that would have been the terms upon which the right of first refusal could be exercised, which would incentivize the owners of the property at that time not to transfer the real estate to some other party who may not be subject to that right of first refusal.
I think the first refusal says too, it has to have a conveyance and it has to be a bona fide purchaser. If you read it together, that's the only way it makes sense. Because the way you read it, they could have picked it up for nothing because there was not really a bona fide purchaser. It was just a spouse to correct a deed.
I think that's right, Your Honor. That would be that interpretation. Is there would be no dollar amount to put in that situation
The laws in the state for real estate transfer tax recognizes that transfers between husband and wife for no consideration aren't subject to any transfer tax because they're really just correcting or putting deeds in both people's names. I mean, the legislature has recognized that when you deal with the transfer tax.
Yeah, I apologize, Your Honor. I'm not familiar with the tax implications or the tax statutes. But the estate would contend that there was a conveyance, and whatever the terms of that conveyance were would be the terms upon which the rotting houses would have had the opportunity to exercise their right of first refusal in this case, as notwithstanding the fact that there was no money potentially that exchanged hands at that time in 2005. The three issues that were presented to the Court of Appeals, the timeliness issue was properly decided by the Court of Appeals, that the defense of 614-17A was properly raised in a motion for summary judgment based on authority from the McElroy case and a few other cases. There was no showing of prejudice in the record to the appellants from the allowance of the assertion of 614-17A. The Court of Appeals properly allowed or properly affirmed on that ground. The second issue on appeal was whether or not the estate was the proper party to assert 614.17A. This was a ground that was not advocated at the district court, and the Court of Appeals properly held that the error had not been preserved on that issue. The third ground advocated at the Court of Appeals was whether or not an interest in a right of first refusal is an interest in or claim to real property. And based on the Westlake decision, which specifically by the Court of Appeals addressed this question in the context of 614.17A, but in addition, based on this court's language in the context of the rule against perpetuities, and specifically the Henderson v. Mills case, in which this court held that rights of first refusal and other preemptive rights are subject to the rule against perpetuities. And the rule against perpetuities, of course, applies to, quote, non-vested interest in real property. This court's prior holdings support the finding that a right of first refusal is an interest in real property subject to 614.
The Westlakes is an unreported decision. I mean, so it's not really binding, as I understand it.
You're absolutely right, Your Honor. It is an unreported decision that would, of course, not be binding on this court. The reasoning of this court in the Henderson v. Mills case with respect to rule against perpetuities demonstrates that in previous contexts, this court has considered a right of first refusal to be an interest in real property. The Iowa legislature has done the same thing with respect to statutes related to Iowa DOT right-of-way provisions, section 307.36, which states, quote, options, easements, rights of first refusal, and other property interests, close quote. So the legislature has also at least understood or contemplated that rights of first refusal are property interests.
Would you agree that a reasonable interpretation of 614-17A sub 1A that a claim arising more than 10 years earlier is barred, that the claim doesn't arise until there's a bona fide purchase or conveyance, that's when the 10-year clock starts running?
I think my understanding of 614.17a is that you can have such a claim against real property, whether it be a right of first refusal or whatnot, that exists for 10 years. If after 10 years you haven't exercised it, you need to re-register.
There doesn't have to be something that triggers the right, or like a buyer in the wings to trigger the right of first refusal. It's just if it has existed for 10 years, you got to keep renewing it?
I think so, Your Honor. I think the alternate interpretation would mean that if there were a triggering event, something that triggered the right of first refusal, and then you had 10 years within which to assert your claim, that would result in a significant delay in establishing and really solidifying rights to the real property. The idea here being that I think if you have an interest that you've obtained in some form or fashion, if it's not exercised or used within 10 years, we need to keep upping it. Otherwise, it goes.
I mean, looking at the statute, it says action to recover or establish an interest in or claim to real estate. And then it says the action is based upon a claim arising more than 10 years earlier. So your point is they really mean something like action is based upon an interest or claim arising more than 10 years earlier. Because clearly the interest arose more than 10 years earlier. Maybe the claim in the sense of, some of us are litigators. We think of lawsuits. Maybe the ability to file a lawsuit didn't arise more than 10 years before.
You're right, Your Honor. I do not interpret the notion of a claim arising 10 years earlier to be a lawsuit filed or a claim in probate made, but the interest in real property, the claim or interest in real property, which in this case is specifically a right of first refusal, but I suppose could take other forms as well. With just a few seconds left, Your Honor, I think there is support in the record based on the issues presented to the Court of Appeals to affirm the decision of the Court of Appeals and the summary judgment entered in favor of the estate. In the alternative, there are other grounds that were presented by the estate to the district court which would support summary judgment in this case. The text and purpose of 614.17a supports the estate's interpretation of that statute and the application of it in this situation, but the court does not need to address that based on the alternative grounds presented by the estate to the district court, and also the, in our opinion, impropriety of the appellant's presentation of that issue to this court on further review, but not to the Court of Appeals below. Thank you, Your Honors, for your time today.
Thank you very much. Any rebuttal?
Just a few points. I'm not going to go over what we went over before. So we had no interest in this property. We had no lien against the property. We don't pay taxes on the property.
Well, you did have an interest in the property. You had an interest of a right of first refusal.
We had a contractual right, yes, Your Honor. But
and it seems to me that it may make sense from a policy standpoint from the legislature to require you to renew this. You don't renew it every 10 years because it has to be before, is it 1980 now? They have 20 or 20 years to give you leeway. But it seems to me that this property was passed down for about 6 generations without a sale, which might be 100 years. It seems to me that, when the last person sells it 100 years later, that first right of refusal may be an interest that they don't want in the chain of title. I mean, there are possibilities if it's just handed down from estate to estate to estate to estate. You'd never get the right of first refusal, but this thing would be there forever. And I think maybe the legislature meant that with this section.
Well, I see the right of first refusal as a speed bump in the road, Your Honor. It's not. It It didn't restrict the passage of this property, for instance. This property went to somebody else.
Should 100 years later someone be able to go in there and say, I had a right of first refusal? I mean, when someone dies, do they pass this right of first refusal to their heirs?
No, Your Honor. I think it's to the grantors, which this one was written that way. I think it's to the grantors. So, and in this case, I think it meant Desi and John Rottinghouse, and not their heirs, not somebody else, Your Honor. So I don't see that as being a problem here, again, because of the fact that, again, it goes away. It went away in this instance, except for our contractual claim that it was violated by the estate.
Could you, instead of asking for money damages, could you ask for specific performance?
I don't think so, Your Honor. I think it's gone. I think that...
Can't you go against the purchasers for specific performance? Because right of first refusal was in the chain of title, and they should have had knowledge of it.
Their attorney didn't present that into title opinion to them, Your Honor. I think that they had good faith as far as buying the property. I don't think we can go after them for violating a right they had no idea was there.
They're on notice of it. I mean, if their attorney goofed up, that's a different matter, but it is in the recorder's office, and they're given notice of it.
To the extent that they would have notice as a layperson, Your Honor, I think that would be kind of a stretch as far as their ability to realize that there was something in there that they should have been aware of, Your Honor. So we did not pursue that claim against them.
What about the breach of contract claim against the estate? I think it's Judge Vogel in her dissent suggests that you would have that anyway. Is that your position as a backup, that you have that claim? Now, as I hear opposing counsel, they're saying, well, you didn't really make that argument. That was one that the Court of Appeals dissent made for you. Is that correct?
Your Honor, we didn't make any other argument besides the fact we were owed money for the fact that they violated our contractual rights here. So, I mean, I didn't, in the actual proof of claim that we made, or that the other attorney, I should say, made in this case, I don't think they said contractual rights, but certainly when we're asking for damages, we're asking for a contractual remedy here, Your Honor. So, as far as the rule against perpetuities goes, I don't see how this applies again to this case. It's been a long time since I've had any familiarity with the rule against perpetuities, but it's 21 years in lives and being, and the Rottinghouses are both here today. They're alive. I don't think the rule against perpetuities applies in this case because it didn't go beyond the rule of perpetuities. As far as the statute of frauds problem that was mentioned, I think that that's, again, something that no attorney, for instance, let's say an attorney examined this within 10 years. No attorney that I am aware of that does real estate examinations would not mention this in a title opinion. The statute of frauds has no application here. And finally, the argument that that this contract somehow was not binding upon the people that got the deed. I think that they were aware that in the deed was this language. They were agreeing to this language. They accepted this language by recording this deed and taking the property. So I don't think you can make a reasonable argument that they're not bound by that language. Thank you.
Thank you very much. In the matter of the estate of Sandra R. Franken, deceased, is now submitted. We are ready for the arguments in State v. Boyer.